The protection of rights in the Australian Constitution. What are the meaning of rights? In 1901, the Commonwealth of Australia was federated and was no longer a scatter of British colonies. Australia was founded and still today a constitutional monarchy which enforces a constitution to be the sole stone of the Commonwealth in regard to making laws. The Australian Constitution is designed to uphold individual rights, which protects citizens from discrimination, provides entitlement, and allows basic human rights to be upheld. Many people claim that they are entitled to such rights as a right to life, a right to choose, a right to vote, a right to work, and a right to asylum. These are all valid human rights, but in practice, some of them are not adequately protected enough. What rights are protected in Australia? Since Australia does not have a Bill of Rights, the Constitution includes both explicit and implicit rights to provide the Australian public with a sense of protection. However, there are only 5 explicit rights that are written in the Constitution, which include the right to trial by jury under Section 80, the right to a range of religious freedoms under Section 116, it prohibits the imposition of any disability or discrimination on account of state residence under Section 117, the right to freedom of trade between the states under Section 92, and the Commonwealth may only acquire property on just terms under Section 51. Even though the Australian Constitution contains a limited number of rights, basic human rights are still well protected. This is evident through the ratification of various treaties, the introduction of committees, and the creation of law either through legislation or common law that grants citizens remedies when they believe their rights are breached. For example, the Australian Human Rights Commission is used as a remedy for discrimination based on the human rights that are labelled in various United Nations treaties. Legislation can also go hand in hand with these commissions, as people can complain to such committees as the Australian Human Rights Commission by referring to Section 46P of the Australian Human Rights Commission Act of 1986 and Section 18C of the Racial Discrimination Act of 1975. Is there enough protection through explicit rights in the Constitution? By referring to Section 116 of the Constitution, we recognise that a range of religious freedoms are protected. However, there have been many instances in recent times where this constitutional right has not been protected. One of those major cases of 2019 was when Israel Folau, a well-known rugby player, was fired from his employer due to expressing his Christian values. Even though the Constitution allows him to express his religious freedoms, he was fired on the basis of religious beliefs. The Fair Work Act could not even protect Folau, as the Fair Work Act under Section 772 suggests it is unlawful to terminate employment on the basis of religion. The explicit right in its own clearly provides a lack of protection for Australian citizens. It must also be noted that religious freedoms can be interpreted and overruled by state legislation. Queensland University professor Dr. Alex Deegan has stated that any constitutional protection of religious exercise in Section 116 is questionable due to the historically narrow construction of the Free Exercise Clause by the High Court. This means that religious freedoms are able to be interpreted by the High Court, meaning the explicit right in Section 116 is not fully protected. This can be clearly seen in Adelaide Company of Jehovah's Witnesses Incorporated and the Commonwealth in 1943, when the Jehovah's Witnesses were briefly banned by the Commonwealth due to certain wartime regulations. The end of the ban was found to later be invalid. However, it raised questions of the extent to which religious freedoms are protected in the Constitution. A key finding in this case was made by the High Court Justices of Rich, Stark and Williams that found religion of freedom was not absolute and could be subject to restrictions necessary for the preservation of the community. What can be done to further protect this right? Religious freedoms and other significant rights in the Australian Constitution can be further protected through the introduction of new legislation. The Religious Freedom Bill, which was first drafted in 2019, is a clear step forward in protecting the constitutional right to a range of religious freedoms. The bill will provide comprehensive protection against discrimination on the basis of religious belief or activity in specified areas of public life. The introduction of more state legislation regarding protection religion is also sorely needed, as New South Wales and South Australia do not have any legislation that specifically prohibits discrimination on the basis of religious belief. But mainly, if Australia really wants to ensure the rights of their citizens are protected and that they are free from discrimination, the construction of a Bill of Rights is very much needed. This was attempted in 2017 by independent Minister of Parliament Andrew Wilkie, who introduced the Australian Bill of Rights into the House of Representatives. Unfortunately, the bill was not passed in August 2017. However, it raised major issues in the current legal system as the bill sought to make Australian legislation invalid to the extent of its inconsistency with the rights provisions contained within it. Overall, the Australian Constitution does have written protection for religious freedom under Section 116. However, through High Court interpretation, legislation, and various legal battles, we can evidently see that the Australian Constitution does not adequately protect the religious rights of Australians.